South Carolina has a landlord-friendly breaking lease framework with a statutory duty to mitigate that provides a clear foundation for handling early terminations. The governing law is found in the South Carolina Residential Landlord and Tenant Act, South Carolina Code, Title 27, Chapter 40, which addresses the landlord's obligations when a tenant vacates early and the tenant's liability for breach. If you're a landlord or tenant in South Carolina, the statutory framework provides reasonable clarity, though the state's overall approach gives landlords more flexibility than heavily regulated states. Let's start with the landlord's duty to mitigate damages. Under South Carolina Code, Section 2740-730, when a tenant abandons the property or breaks the lease before the end of the term, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. This is a codified obligation, not just a common law principle, and South Carolina courts enforce it. The landlord must take the same steps to re-rent the vacated unit that a reasonable landlord would take to fill any vacancy: advertising the unit, showing it to prospective tenants, and accepting a qualified applicant who meets the landlord's standard screening criteria. The landlord cannot deliberately leave the unit vacant and collect the full remaining rent from the departing tenant. If the landlord successfully re-rents, the departing tenant's liability is limited to rent for the vacancy period, plus the landlord's reasonable costs of re-renting, including advertising, cleaning, make-ready repairs, and any leasing expenses. If the replacement tenant pays less than the departing tenant was paying, the departing tenant may be liable for the difference through the end of the original lease term. If the landlord fails to make reasonable mitigation efforts, the departing tenant can argue that damages should be reduced by the rent the landlord could have collected through reasonable efforts. South Carolina courts evaluate what's reasonable based on the specific circumstances: the local market, the property's condition, the landlord's typical marketing practices, and the time of year. South Carolina's statute also addresses the landlord's right to recover specific categories of damages when a tenant breaks a lease. Under Section 2740-730, the landlord can recover unpaid rent through the date the unit is re-rented, the landlord's reasonable costs of re-renting, and any rent deficiency if the replacement tenant pays less. The landlord can also retain the security deposit to cover these damages, subject to the standard deposit return procedures. Early termination clauses are generally enforceable in South Carolina. The state does not have a specific statute capping early termination fees. South Carolina courts enforce reasonable contractual provisions, and a clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and defensible. The fee must represent a reasonable estimate of anticipated damages. A clause imposing an excessive penalty could be challenged under general contract principles, but South Carolina courts give reasonable deference to negotiated terms. Some South Carolina landlords use a liquidated damages approach, specifying in the lease that the tenant will owe a defined amount if they break the lease early. Others use an actual damages approach, holding the tenant liable for actual losses, including vacancy rent and re-rental costs, reduced by mitigation. Either approach is workable under South Carolina law, but the liquidated damages amount must be reasonable. Military members have the right to break a lease under the Federal Service Members Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. South Carolina has a substantial military population. Joint Base Charleston, encompassing Air Force and Navy operations, is a major installation generating significant rental demand in the Charleston metro. Fort Jackson, near Columbia, is the Army's largest basic combat training installation and generates enormous rental demand from both permanent party soldiers and trainees' families. Marine Corps Air Station Beaufort and Marine Corps Recruit Depot Paris Island generate military rental demand in the Beaufort Port Royal area. Shaw Air Force Base near Sumter generates demand in the Sumter-Dalzell corridor. SCRA lease terminations are a routine occurrence across South Carolina's military communities. Landlords near any of these installations should have a standardized SCRA process. verify orders, accept notice, calculate the termination date, waive all fees, and process the deposit return within the standard timeline. South Carolina has enacted protections for victims of domestic violence that allow early lease termination. Under South Carolina Code Section 2740-530, a tenant who is a victim of domestic violence or criminal sexual conduct can request early termination of the lease. The tenant must provide written notice to the landlord along with qualifying documentation. The qualifying documentation must include a copy of an order of protection or proof that the tenant has filed for an order, a police report, or a report from a qualified domestic violence service provider. The tenant must provide at least 30 days written notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 30 days of the tenant vacating. South Carolina's provision also addresses situations involving co-tenants. If the victim tenant and the perpetrator are both on the lease, the victim can terminate their portion of the lease obligation, and the remaining tenant's obligations continue. The landlord cannot hold the victim liable for the perpetrator's subsequent lease violations or unpaid rent. Tenants in South Carolina may break a lease if the landlord fails to maintain habitable conditions. Under South Carolina Code Section 2740-440, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises in a fit and habitable condition, and maintain the structural integrity, plumbing, heating, electrical systems, and common areas. If the landlord fails to maintain the property and the failure materially affects health and safety, the tenant has remedies under Section 2740-610. The tenant must provide written notice to the landlord identifying the specific deficiency. The landlord then has 14 days to make the repair for non-emergency conditions. If the landlord fails to act within 14 days, the tenant may terminate the lease by providing written notice. For conditions that pose an immediate threat to health or safety, such as a gas leak, sewage backup, or structural failure, the response time is shorter, and the tenant may take more immediate action, including termination. The notice and cure process is important in South Carolina. The tenant must provide written notice and allow the landlord the statutory repair period before terminating. Simply vacating without following the process weakens the tenant's legal position and may result in liability for the remaining rent. Documentation is essential. Written notices, photographs of conditions, dates of communications, and the landlord's response or lack thereof. South Carolina also recognizes constructive eviction as grounds for termination. If the landlord's failure to maintain the property or the landlord's affirmative conduct, such as shutting off utilities, removing doors or windows, or engaging in harassment, renders the property uninhabitable, the tenant can treat the lease as constructively terminated. The tenant must vacate within a reasonable time to establish the claim. South Carolina has specific provisions regarding abandonment under Section 2740-730. If a tenant abandons the property, leaves without notice, removes personal belongings, and stops paying rent, the landlord can retake possession and begin re-renting. The landlord should document evidence of abandonment before entering. Unpaid rent, absence from the property, removal of belongings, disconnected utilities, and failure to respond to contact attempts. The departing tenant remains liable for damages after abandonment, but subject to the landlord's statutory mitigation duty. The landlord must make reasonable efforts to re-rent even after abandonment and cannot simply pursue the full remaining rent without trying to minimize the vacancy. From a practical standpoint, South Carolina has one of the fastest growing rental markets in the Southeast, and the local market directly affects the financial consequences of breaking a lease. Charleston has emerged as one of the most desirable rental markets in the region. The economy is driven by Boeing's manufacturing operations, the Port of Charleston, Joint Base Charleston, healthcare, including the Medical University of South Carolina, tourism, and a thriving technology scene. When a tenant breaks a lease in Charleston, the landlord can typically re-rent quickly, often within 2 to 4 weeks in desirable areas like Mount Pleasant, downtown Charleston, and the West Ashley corridor. The departing tenant's financial exposure is usually minimal in Charleston's strong market. Military lease breaks from Joint Base Charleston are a regular part of the Charleston rental market. The constant rotation of military personnel creates ongoing demand that helps absorb vacancies created by departing tenants. Columbia, the state capital and home to the University of South Carolina, has a diverse rental market. The combination of state government, the university, healthcare, and Fort Jackson creates layered demand. Student lease breaks are common and seasonal. Timing matters. Fort Jackson's training cycle creates its own lease break patterns. Re-rental in Columbia is moderate, typically 2 to 4 weeks in desirable areas and longer in less competitive neighborhoods. Greenville has experienced remarkable growth and has one of the strongest markets in the upstate. The economy is driven by BMW manufacturing, healthcare, and a revitalized downtown. Re-rental in Greenville is generally quick. Myrtle Beach and the Grand Strand have a seasonal dynamic. The tourism economy creates workforce housing demand during the summer. A lease break during spring can be filled quickly with incoming seasonal workers. Off-season breaks take longer. Landlords in the beach markets should account for seasonal patterns when evaluating lease break liability. Hilton Head and Beaufort have unique dynamics. Hilton Head's resort economy and Beaufort's Marine Corps presence create different demand patterns that affect re-rental. Spartanburg, Rock Hill, Anderson, Florence, and Sumter have more moderate markets with varying re-rental timelines. Sumter, near Shaw Air Force Base, has a military-influenced market where SCRA terminations are routine. Clemson, home to Clemson University, has a tight student market where timing is everything for broken leases. One best practice for South Carolina landlords: include a clear early termination clause in your lease that works alongside the statutory mitigation framework. Specify the notice period, the fee amount, and how it interacts with the landlord's duty to mitigate. For example, a clause might state that the tenant can terminate with 60 days' notice and a fee equal to 2 months' rent, or the tenant's actual liability for vacancy rent and re-rental costs, whichever is less. This structure gives the tenant a predictable maximum cost while preserving the landlord's right to recover actual damages. Another best practice: begin re-rental efforts immediately upon learning that a tenant intends to break the lease or has abandoned the unit. South Carolina's statutory mitigation duty under Section 27-40-730 means you must act promptly. Document every step: listing dates, advertising platforms, inquiry counts, showing dates, costs incurred, and when you accepted a replacement tenant. This documentation is your evidence of reasonable mitigation. A third best practice for landlords in military communities: develop a standardized SCRA process that your entire team follows consistently. Verify orders, accept notice, calculate the termination date, waive all fees and penalties, process the deposit within 30 days, and document the entire process. Military families communicate extensively. A reputation for smooth SCRA processing generates referrals and helps maintain high occupancy rates. South Carolina does not have a specific statutory cap on security deposits under the Residential Landlord and Tenant Act, though standard practice is 1 to 2 months' rent. The landlord must return the deposit within 30 days of the tenant vacating, along with an itemized list of any deductions. If the landlord fails to return the deposit within 30 days, the landlord may forfeit the right to retain any portion and may be liable for up to 3 times the amount wrongfully withheld plus attorney's fees. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to South Carolina breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.